It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like, how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my boomeranging co-host, Brett.
Boomeranging. Okay. I see what you're doing there, Alice. But
You see?
That one might have been a little bit of a stretch, but I'll give it to you.
I'm not sure boomeranging is really a word or a descriptor.
I'm not sure.
But if you guys are following my absolute love of puns and continuity within my superlatives and the theme, you'll see what I'm trying to do, which is that you get back to where you started, having taken a circuitous route, shall we say.
There you go, Alice. And as you guys know, nothing Alice does is an accident. And the case we're going to talk about today is exactly that, where someone had the, I don't know how you describe it, good fortune, misfortune to be released from prison. And then on appeal, their conviction was reinstated and they had to go back to prison. So we're talking about the Crosley Green case today. It's a case a lot of you know about, a case out of Florida. And it's a pretty interesting one. And it raises a lot of sort of legal questions in one way, but in another is such a straightforward case that it is very much, there is sort of the legal side of this case, and there's the more emotional side of this case. And the emotional side of the case gets most of the press, obviously. But we wanted to walk you guys through the legal side so you understand, as we try and do, why things happen. Whether you agree with them or not, whether you think they're good or bad, why do things like this happen? How does the system work? And how did this happen to Mr. Green? So let's just jump right in, Alice, if you're okay doing that.
Let's go for it. So for those of you who don't actually know about what Mr. Green was convicted of, Brett, tell us.
Yeah, so back in 1989, so this is an old case, Green was convicted of killing Chip Flynn in a Florida orange grove. And this case has an interesting history. Well after Green was convicted and all his appeals had failed, he filed what is called a federal habeas petition. It's under 28 U.S.C. 28 U.S.C. 2254. I always forget what the
number at the front is, because everyone just calls it a 2254 motion.
Exactly. It's a 2254 motion, which is it is a habeas petition that you file in federal court when you're challenging a state conviction. So if you're challenging a federal conviction, you file a 2255. This is a 2254. This is when I worked in the state, this is one of the things I dealt with a lot. And this is a post-conviction appeal, a habeas petition, whatever you want to call it. This is not a direct appeal of your conviction. Those appeals have been exhausted. And now you're saying, look, there was something unrelated really to the evidence in the case, a constitutional violation usually, or an ineffective counsel that undermines my conviction, so I should have another shot, even if it looks like the evidence is pretty bad for me. That's essentially what you're doing. And procedurally, you're supposed to file this within a certain amount of time. You have about a year from certain triggering events. This was well after what the first triggering event would be, which is the end of your state appeals. So usually when your state appeals are done, you have 1 year to file a habeas petition. But there are other things like newly discovered evidence or a new rule of law that can raise this. And so this was actually based on newly discovered evidence. And initially, the district court actually ruled the motion was untimely. You don't even get to file it. You filed it so late, we're not even going to hear your argument. It goes up to the 11th Circuit Court of Appeals, and they reverse the district court. And this is a Florida case. The 11th Circuit is over Florida, Georgia, and Alabama. They reverse the district court, and they say, nope, you're going to have to hear that argument that this person's making. It is timely, and it goes back to the district court for consideration on the merits. Ordinarily, when a district court dismisses something like this as untimely, in the back of the court's mind, it's also thinking the substance here is weak too. Because when courts think you have a really strong substantive case, they often will kind of try and get around the time limits because they want to hear the merits. So typically, this would be a loser anyway. It's going to go back to the same district court that dismissed it as untimely. They're not going to grant it on the merits. This case, however, went differently than you might expect. The district court did something surprising. It agreed with Green. It agreed with him that there was a constitutional flaw in his conviction, vacated the conviction, and ordered a new trial. So, here's how the court described the facts of the case, for those of you who are unfamiliar with the factual background. Late in the evening of April 3rd, 1989, Kim Halleck and Flynn, whom she had dated, drove to a park in Flynn's pickup truck. They parked near dunes in a wooded area and smoked marijuana. As they smoked, a sheriff's car drove by and shined its spotlight, but did not stop at the truck. After the sheriff's car passed, a man walked in front of the truck and stopped at the driver's door. He warned Halleck and Flynn to watch out for the police, then walked on.
And a few minutes later, Flynn stepped outside the truck to relieve himself. Halleck testified that she soon heard Flynn say nervously, "Hold on, wait a minute, man, hold on, put it down." She retrieved a gun from the truck's glove compartment and put it under some jeans on the seat next to her. She testified that when she looked outside the truck, she saw the man she had seen earlier. He was now walking around Flynn and carrying a gun. The man ordered Flynn to the ground, then asked if either of them had any money. Halleck gave him $5, but Flynn said he had no money. The man then tied Flynn's hands behind his back with shoelaces. While tying Flynn's hands, the man's gun went off but did not injure Flynn. The man pulled Flynn off the ground and found a wallet in his pants and threw it to Halleck, who counted $185.
Now, let me just say, if someone's robbing you, just give them the money. I mean, not saying that Flynn deserved this by any stretch of the imagination, but one of the big things that you see in cases like this a lot, people get robbed, they try and not give the money to the robber, and that's when bad things happen. I know $185 probably seemed like a lot of money, but telling the man he didn't have the money, if he'd just thrown him his wallet, maybe he just would have ran off and we wouldn't have this case. But really unfortunate that this went the way it did. At this point, the man orders Halleck to start the truck and move to the center seat. He puts Flynn in the passenger seat and starts driving. And he forced Flynn and Halleck to ride with their heads down and held a gun to Halleck's side. During the ride, Flynn found the gun Halleck had hidden under the jeans. The man stopped the truck at an orange grove and tried to pull Halleck from the truck. Halleck freed herself and ran around the truck, but the man caught her, threw her to the ground, put a gun to her head, and threatened to blow her brains out. Flynn got out of the truck and fired a shot, but missed the man. Halleck jumped into the truck and locked the doors. She testified that she saw the man fire a shot. Flynn yelled for her to escape, and Halleck drove to a friend's house and called the police. When police arrived at the orange grove, they found Flynn lying face down with his hands tied behind his back. Authorities found a loaded .22 caliber revolver nearby. Flynn was alive when police arrived, but he stopped breathing several times and died of a single gunshot wound to the chest before paramedics arrived. Halleck later identified Green as the man she saw in the park.
So kind of a horrendous set of facts. I mean, this was a long drawn out event, right? It wasn't just a one stop, a man comes, tries to rob him and shoots him to death. There's a chase, there's driving, there's a flight. I mean, these are harrowing facts. But where does Green come in? So here's some of the evidence against Green, the eyewitness testimony of Halleck, who also picked out Green out of a 6-person lineup. And obviously, when you heard those facts, Halleck is the survivor of this just terrible situation. So she identifies him out of a lineup, and she obviously can explain everything that happened firsthand. A scent dog tracked from some prints around the dunes went to Green's house, and Green told a friend, quote, "I effed up, man, I effed up." When asked what that meant, Green told him, quote, "Some people came through and was trying to buy something from him, and they tried to get him, and he said he just effed up." Green's sister testified that when she asked him about the shooting, he said, quote, that the dude pulled the gun on him and motioned for the passenger, which is the girl, to run for help. He said that it was a matter of either him or the other guy. Another friend testified that Green told him that he'd killed the guy and needed to disappear. Green's own sister also testified that she saw Green the day after the murder, but then he just disappeared. It took police months to find Green, and the judge gave a flight instruction to the jury.
And a flight instruction just means the jury can consider the fact that you ran as evidence of your guilt. It's evidence that you have a guilty conscience, and that's why you ran. And they can be a little controversial because maybe the police are just incompetent and couldn't find him, but that was sort of the basis for giving that instruction. Now, Green, for his part, claimed to his attorney that he was smoking crack that night and he was selling cocaine out of a friend's house. So he couldn't have been the killer because he was somewhere else. That was his alibi defense. It's not the greatest alibi, and his attorney actually told him, there is no way I'm presenting that at trial. Green would later use this as a ineffective assistance of counsel claim, but obviously this is a strategic decision, tactical move by the defense attorney, and hard to argue with him.
I mean, just so you know, some of you, even if that really is his alibi, you can understand why his attorney would decide not to use this. We won't get into the ineffective assistance issue here. That's another episode. But you can imagine that some jurors will hear that you're smoking crack and selling cocaine, like illegal activity, and just decide you must be illegal for another reason. We've talked a lot about this with 404B. This is the type of evidence that the prosecution would want to bring in, and the defense usually wants to keep out, not use it as their affirmative defense.
And look, we're going to talk about the facts of the case and how some of the evidence falls apart. When you hear this, to me, the real story starts to come out, and it's not the story you heard from the girlfriend. It's they were going to buy drugs from him, and the drug deal went wrong, and somebody ended up getting shot. As I've said before, truth in every lie, right? Like, I think the story you're hearing doesn't really make sense from her. He's saying he was selling drugs that night. When you put the two together, it kind of makes sense. So that's sort of my theory on this, to get a little ahead of ourselves. But so he says, hey man, I was selling crack. Attorney says, not going to use that. In his 2254, though, the main focus was a Brady claim. Talked about Brady versus Maryland before. Got to turn over all potentially exculpatory evidence that is material. And he says, look, they didn't do that. And his allegation was that the police officers who first responded that night, Sergeant Diane Clark and Deputy Mark Rixey, believed that it was Halleck, the girlfriend, and not Green who killed Flynn. These two officers relayed that information to the DA, who took notes on it, but he failed to turn those quote-unquote investigative conclusions over to the defense attorney. According to the district court, these suspicions were aroused because Halleck never asked how Flynn was doing, she would not go to the scene of the murder, and she drove all the way to a trailer park to ask for help from a friend when there were other avenues of help available, including lots of different houses, and I believe even her parents' house. But she drove all the way to this friend's house rather than stopping at any of those. It's not entirely clear that the defense attorney, John Robertson Parker, was not aware that the police felt this way, that Halleck was a viable alternative suspect. This is a little muddled. He is also later deposed, and he said the following about why he personally thought that Halleck was involved. And this is lengthy, but we're going to read it to you because it also lays out some of his theory of the defense of this case. He said, there were several things. Number one, the manner in which the victim had been tied. He certainly appeared to have been tied for comfort purposes, as opposed to for security purposes. He was tied in a manner which I couldn't envision another man who was afraid for himself, potentially as Mr. Flynn was another male. I can't imagine another man tying him that way. Now I want to stop here for a second, because one of the notes the police took actually says that she tied his hands. And the way this has been interpreted by folks on the prosecution side is, yeah, you're 100% right. Another man wouldn't do this. He ordered her to do it. She did tie his hands, and that's why it was sort of a loose tie, right? Probably not the smartest thing for him to do to tell her to do that, but that is what she told the police that night. So that actually is consistent with the prosecution's story, and this thing the defense attorney is saying actually hurts his client, doesn't help him. Second of all, there was a broken glove box in the truck. In that particular glove box were many items that when they would hit the floor would make noise. Evidently, according to Miss Halleck, she had reached into the glove box and there were tapes and other items that would have made considerable noise when they fell from the glove box. She testified, as I recall, that while the perpetrator had Mr. Flynn out on the ground is when she reached into the glove box to retrieve a loaded .22 caliber pistol.
And he goes on to say, I found it unbelievable she could do that. All of these things could fall out on the floor, and the defendant, who was standing there at the door, if she testified correctly, didn't hear that, look in there to determine what the heck was going on. I found it unbelievable that Miss Halleck would drive to the killing field, if you will, when she had a loaded .22 caliber pistol under her and not shoot the guy, when her testimony was that Mr. Flynn was by eyes and other movements indicating, shoot this guy. I find it unbelievable that she would say, I'm too afraid. Her whole description of this person absolutely was not Crosley Green. She had lied about smoking marijuana, and she finally admitted that at the suppression hearing. She had been, in my opinion, spurned because Chip had engaged in a sexual relationship with another woman subsequent to a relationship with her. That was coming back to her for whatever reason. I found it incredibly unbelievable that she would drive that truck out of there and not go to the hospital, which was approximately a mile up the road and lit up like the shuttle launch pad, instead of going to some man's house in some obscure neighborhood at this time in the morning that she didn't know for help.
This is actually a pretty good argument the defense attorney is making, by the way, but he continues. There were clothes that were placed out on the ground. They were matted down as if someone was going out in the woods to make love. These were two young people. The way that he was actually shot appeared to me to be more of a ricochet than anything else. It didn't appear to be some sort of firefight where two people were shooting each other like that. Her story was unbelievable because he said he dove out of that truck and would have, and by the way she described it, he would have slid across the ground on his chest. No injury to his chest, no burns, no nothing. It was a portion of a round that actually lodged in him that caused his death. I found it unbelievable that when the law enforcement finally arrived, that when they asked him who did it, he would say, I just want to go home. I just want to go home.
Everything about what she said, the fact that she jumped in the truck and sat there for some period of time and this person didn't approach and grab her, and there was a wound on the deceased's leg, I believe the tags of the wound indicated at first that he might have been run over. Her position was she ran over the guy. That didn't happen according to the medical examiner. What happened was that wound was caused by a dragging motion, and it was consistent with her dragging him to get him to the truck and not being able to. The whole thing was consistent with this thing being an accident, and she not knowing what to do and making up this story. And I implied that without explicitly saying it to the jury. So that's what the defense attorney had to say. And by the way, it's very well thought out. And the district court concluded that because the defense attorney was already onto this theory, it was particularly prejudicial that the prosecution didn't share information that would have bolstered it. Which
I just want to tell you, it is a little bit of a spoiler alert. That is a terrible evaluation by the district court of Brady evidence. And we're going to talk more about this in a second, but I really feel like, and it's such a strange thing, because the district court clearly was following the law, or thought it was following the law when it said the petition was untimely. Then it gets reversed by the 11th Circuit. But then it really seems like the district court went out of its way, based not on a Brady violation, but more the strength of the evidence in Green's favor to find this, because this is a very weak analysis. And you're going to see that once we get to the 11th Circuit opinion. So that is sort of the defense attorney. He makes this argument. It sounds like a pretty good argument, but we went through some of that evidence that the prosecution had, which also seemed pretty strong. Well, what about that? What about the other testimony? We still have Green's sister and his two friends. So that's Sheila Green, Lonnie Hillary, and Alan Jerome Murray. But there's some problems with his testimony. Sheila Green and Lonnie Hillary were actually engaged to be married and had 2 kids together. But the more interesting connection between them is that they were co-conspirators in a federal drug case for which they were promised leniency in exchange for their testimony. Guys, as you know, the world of finance long been a target for criminals looking to make a quick buck. There's always something new out there, some new investment people are wanting you to invest in, get rich quick schemes and everything else in between. And with inflation going up, sometimes you feel like even the dollar bills in your pocket aren't worth as much as they used to be. So take my advice. Protect your financial future and your privacy with something real and tangible. Gold and silver from our friends at Allegiance Gold.
Allegiance Gold can help you protect your IRA or 401k with physical gold and silver, or if you prefer, have it delivered securely right to your front door. Since the beginning of time, there's only one universal currency, and that's always of value, and that's gold. Allegiance Gold has the highest ratings in the industry, 5 stars with TrustLink, a AAA rating with the Business Consumer Alliance, and an A+ rating with the Better Business Bureau. You can invest with confidence because of the quality and service of Allegiance Gold. Get up to $5,000 in free silver on a qualifying purchase when you visit protectwithgoldnow.com today, or give them a call at 844-790-9191. Don't wait for your privacy to be taken away. Protect your future now with Allegiance Gold. Visit protectwithgoldnow.com or call 844-790-9191.
Sheila Green would later say that the police threatened her with the loss of her children if she didn't testify, which probably would have been a consequence of a federal drug conviction and sentence. So I think probably what they're saying is, look, if you go down for this drug thing and you go to prison, they're going to take your kids. You need to testify. You need to help yourself. It's probably what they told her. And eventually, I think a deal was cut where she basically got probation and got cut loose. And then Hillary, her fiance, I believe he actually went to trial and won. So it's kind of ironic that he actually ended up beating that case. But either way, so that's those two. As to Murray, he had an outstanding warrant for his arrest when he was contacted by police and also received leniency for his testimony. Look, this is not rare for people to receive leniency in exchange for their testimony. It happens all the time, but there's a reason it's impeachment evidence. There's a reason defense attorneys always use it, because it does make you question just how much can we trust what we're hearing from these people.
Exactly. And that's really important there for you guys to understand, because we often hear people say, oh, that seems underhanded. It's not. I mean, this is part of how you get testimony. You can't lie under oath, but you do this when you think someone has relevant information and they're like, no way am I going to talk, and you can make deals with them. But note, the defense or the other side has to know about that deal that you're making, and they get to absolutely cross-examine the witness based on the deal that they made, and there kind of is nothing off limits with respect to what they can ask about the deal.
And obviously the state still has the dog evidence. They still have a lot of really other circumstantial evidence. I mean, this is a fairly lengthy, deep trial when it comes to evidence. We're not going to go through all of it today. We're not doing a deep dive on this case, but you can find it if you want to. There are websites that support Green's guilt. There are websites that are against it. You can read both. You can see the circumstantial evidence that the prosecution used to prove this up. I'll just go ahead and tell you, if you read an article on this case, you'll be completely misled, because the articles basically will tell you there's no evidence whatsoever. It was really just the girlfriend's testimony. How can we trust her? This is a tragedy, a travesty of justice. It may be a travesty of justice, but it's not that clear cut. And I think if you really are interested in this case, find those sites, read the stuff for yourself. We talk about this all the time. These cases are way too complicated to be boiled down in a 500-word article on a website that's probably biased anyway. If you really want to know the truth about these things, you need to look at the testimony, you need to look at the trial transcripts, you need to look at the evidence and draw a conclusion for yourself, and that stuff is now available, so check that out if you're really interested in a deep dive on this case. Either way, based on the finding that the state had not turned over the opinions of the responding officers, on July 27, 2018, the district court vacated the conviction and ordered a retrial. This does not mean Green would get out of prison. Ordinarily, you're held in custody pending a trial for murder. You're not going to be released on that. And so initially he remained in prison, but he was eventually released pending retrial because of the COVID-19 pandemic. During the COVID-19 pandemic, a lot of people were released from prison who would have normally stayed there, either to home confinement or early, or in situations like this, he's going to be released basically on bond with the expectation that he won't commit any crimes and he'll show up later. A lot of time had passed. He had a pretty good record in prison, so there was no concern about that. Now, the state did object to this. The state wanted him to stay in pending the appeal, but the court released him. And so for the first time in more than 30 years, he was a free man, and he remained a free man for some time. But the state did appeal, and eventually the 11th Circuit reversed.
And this is not all that surprising. As we've said before, it's not enough to show you didn't turn something over. You also have to show prejudice. And given that Green was well aware of the girlfriend as an alternative suspect and argued as much in court, the initial thoughts of two officers, which are probably not even admissible under the rules of evidence, because remember, we've talked about hearsay, and police reports are hearsay. However, the police officer can be called to the stand. But we're talking about these initial notes at the very beginning of the case. And so the 11th Circuit explained, quote, "More to the point, Green failed to show how knowledge of the officer's opinion would have benefited the defense. Parker had the same opinion. Halleck was the culprit. He based his opinion on the same information the officers relied on in expressing their opinion. In his closing argument in the guilt-innocence phase of Green's trial, Parker all but told the jury flat out that Halleck was the murderer."
In sum, this is the opinion continuing. In sum, the state's non-disclosure of the officer's opinion was immaterial. It would have been of no demonstrable benefit to the defense. Because the opinion of Rixey and Clark were not admissible under state law, they were not evidence at all. And Green failed to argue or demonstrate that the suspicions would have led to material admissible evidence sufficient to create a reasonable probability that the outcome of the trial would have been different. And this is kind of what I was talking about. This was a very weak decision by the district court. It just didn't fit Brady at all. Brady is a really high standard, despite what certain famous cases may have made you believe. It is really hard to make out a Brady claim. And something this insignificant as just the couple of cops who showed up initially thought, maybe it was a girlfriend. Of course they thought that. That's the initial thought of every police officer who ever responded to any murder in which there was a girlfriend, boyfriend, husband, wife. That is their initial thought is, I bet it's him or her. He did some weird things. Might want to look into them. Yeah, you absolutely should. But to think that that somehow is evidence or would be significant, maybe if the defense had no idea. Like, imagine the defense didn't even know there was a girlfriend somehow. They didn't even know there was one. Well then, okay, fine. The prosecution knowing that, knowing she was a potential suspect, knowing she was at the scene, should turn that over. But here, Green had basically all the information. He knew to look at her. There was nothing that would have been gained by having this information about the police. You couldn't have put it in front of a jury. You couldn't have used it in Green's defense. So the fact that the district court went for it, kind of mind-blowing, frankly. As the concurring judge stated, after complaining that the majority's 150-page opinion was too long, which I think it's funny that the judge wrote a concurrence to argue that too much had already been written, but whatever. He says, "As I see things, the case is not as complex as the majority makes it out to be. Even under de novo review," and de novo review means even just looking at it without any bias whatsoever, Mr. Green's Brady claim fails. For those who care about such things, the majority opinion was written by Judge Choflat, who was appointed to the district court by Richard Nixon, and the circuit court by Gerald Ford. Yes, you heard that right. And was joined by William Traxler, who was appointed by Bill Clinton. The concurrence was written by Alberto Jordan, who was appointed by President Obama, and is apparently a fan of brevity. I'm a big fan of Judge Jordan personally because the only case I ever lost after oral argument, Judge Jordan dissented from the majority opinion, because a very wise judge. that he is. And eventually, the Supreme Court reversed the court. So both he and I were vindicated in the end. So big fan of him, but I guess he doesn't like really long opinions. In any event,
I kind of
with the 11th Circuit
love that one sentence opinion.
Yeah, well, with that having been done, the 11th Circuit has now acted. Green remained out until his petition for certiorari was rejected by the Supreme Court. And so on April 17th, 2023, Green returned to prison. His causes of action are essentially exhausted at this point. So barring a clemency petition to the governor, he will likely remain in prison for the rest of his life. Now, look, like I said, this is a complicated case. I'm not sure if Green did it or if he didn't do it. I think if he didn't do it, how this probably went down was he went out there that night and sold these people some drugs. Then he went back to his house. Whatever happened, happened. The dogs track him back. She gives a sketch of him, the girlfriend. She gives a sketch of him that is so accurate that other people in the community see it and are like, I know exactly who that is. And so everybody in the community thought he did this. And so the people who testified against him, that's why they asked him about it, because according to them, everybody was saying he shot somebody because they all saw the sketch. And so they go to him and like, did you shoot somebody? And he tells a story. Interestingly, even if you think their testimony was not true because it was sort of bought off for leniency, the stories that the other witnesses tell are consistent with the girlfriend. The fact that the boyfriend had a gun, that he fired the gun, that then Green shot him, that is what the other witnesses say that Green told them. Now, you might think they were coached or they were fed all that information by the police, but you pretty much would have to believe this is a pretty thoroughgoing frame job to think that Green's innocent. But maybe he is, and that would also explain why the dogs led them back to his house, because he was there that night. He was just there selling them some drugs, not murdering somebody. Obviously, the other option is this went down pretty much the way she said. The one thing I'll say about it, Green's been in prison for over 30 years. He's back in prison now. He was convicted of first-degree murder. This is not first-degree murder in my mind. This seems very clearly to have been a second-degree murder type situation, a robbery gone wrong, even possibly, if you believe what the defense attorney said, like the ricochet thing. I mean, who knows exactly how this went, but I don't know that Green necessarily should have gotten life without parole anyway. And by all accounts, he has sort of fully reformed if he is guilty. If he is guilty, I wish he would admit it, particularly now, because I don't think he really has any avenues left. And personally, if he did admit it and he took responsibility, I wouldn't mind seeing the rest of his sentence commuted. I think these cases are really complicated, and there is a way to deal with these, but it's not through this sort of ad hoc thing the district court tried to do by making up a Brady violation when there isn't one.
Absolutely. So there's obviously a lot more. There was the trial. We barely touched what the opinions, clearly the 150-page opinion from the 11th Circuit. We barely touched upon it. But this is to give you an idea of what happened and how a man who was convicted of murder was able to get out and then now is back where he is, and kind of the ping-ponging of opinions, the boomerang of events, shall we say. And hope that's been able to clear up any confusion that you guys may have on that. Kind of with that, Brett, do you have anything else you'd like to add before we sign off for the day?
The only other thing I'll say is this is a case that it feels unfair in a way because the guy was out and now he's back in. And I understand that. And I understand sort of the emotions behind it. But this is exactly how the system should work. There is an appeal process, a very thorough appeal process that he's been undergoing for the last 30 years. He has had many, many opportunities to go before courts and argue his case. One of those courts bought it and went with it, but the opinion was bad and the reasoning was wrong. And just like he has the option to appeal, the state, who's representing both the victim who was murdered and the people, can also appeal. And when they win, the result is you go back to prison because you never should have gotten out. So while I understand the emotions, and like I said, I'm not against some sort of executive clemency here, I think this is not an example, at least the appeal part. Maybe the conviction is. Maybe the conviction is completely unjust and is a miscarriage of justice. But this process happened exactly the way it's supposed to happen. And the final result was the correct result according to the law.
Well, there you have it. Brett, this is really fascinating to me because I do think most people don't have the time or even know how to access all the opinions to these cases. And you're absolutely right about this. This occurred within the system as it should have. And if you are interested in knowing more, you should go read the 11th Circuit opinion. It's very detailed. And I think will answer a lot of the questions you may have if this short 30-minute podcast hasn't done so. But kind of with that said, we love talking about cases where you guys may have questions about, especially when there are kind of more complex legal issues that are not apparent on their face. So we welcome your thoughts. As always, let us know what you think at prosecutorspod@gmail.com or message us on Twitter, Facebook, Instagram, all the places that we are, and give us ideas of what you'd like to hear on the next Legal Briefs episode. Until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
Sounds like somebody else has something to say.
We almost got through. Until next time, I'm Alice.
And I'm Brett.
Let's try that one more time. Just hold together 5 seconds. Until next time, I'm Alice. Come on, man. Let me just say the I'm Alice part. I'm Alice.
And I'm Brett.
Come on, man. This is pretty hilarious.